Welcome to the deep dive. Today, we're jumping into something really complex, the intersection of international law and, well, massive alleged financial crime.
It's definitely high stakes. We're focusing on a specific case that's been developing.
Exactly. Our mission today is basically to understand how one of the, let's say, most talked about financial fugitives, Mehul Choksi, is maybe finally being brought back into a legal process. And importantly, how the legal system is making that happen.
Yeah, the focus is squarely on Choksi and a really significant recent decision from a court in Antwerp, Belgium. This isn't just about politics, it's a major legal step.
That's the key thing for you to grasp if you've been following this. Sources are calling it the first and very important stage cleared by New Delhi. But, and this is crucial, it doesn't mean it's over. Not by a long shot.
No, definitely not. So, today we're going to look beyond just the huge sums of money involved. We'll unpack the legal tools used for the extradition request, look at Choksi's main defense, which hinges on citizenship, and also get into the very specific human rights assurances India had to provide. That part's fascinating.
Okay, let's start with the scale. Mehul Choksi, this isn't small-time stuff, is it? What are the actual accusations and how much money are we really talking about?
We're talking about 6 separate bank fraud cases. These are alleged to have happened between 2018 and 2022. And the number, well, it's huge. Nearly 13,000 crore rupees.
13,000 crore. Just pause on that for a second. That's astronomical. It signals massive potential economic damage, which explains why the pursuit has been so intense. The CBI, India's Central Bureau of Investigation, has been leading this, right?
Absolutely relentless is the word. They tracked Choksi to Belgium back in July of last year. Then, based on India's formal extradition request, Antwerp police arrested him on April 11th this year.
And he's been held since then.
Yes, for over 4 months now. And what's really telling is that he's tried multiple times to get bail from different Belgian courts and failed every single time. The courts seem pretty convinced he's a flight risk.
Yeah, that failure to get bail really underlines the seriousness in the eyes of the Belgian system. Okay, so that sets the scene for the actual court ruling on the extradition itself. What did the Antwerp court actually decide?
Well, the court heard arguments from both sides. On a Friday, you had the Belgian prosecutors acting for India and Choksi's legal team. The ruling was pretty clear-cut.
Which was?
They ruled that his arrest was valid and, crucially, that India's extradition request itself was legally sound and properly substantiated.
Okay, so that's the green light, legally speaking. But getting that green light internationally, especially in Europe, requires ticking a lot of boxes. What specific laws did India use to build their case for extradition? It can't have been simple.
Oh, it's incredibly complex. They didn't just rely on one charge. They built the request around several key sections of the Indian Penal Code, the IPC.
Like what's specific?
Well, first, criminal conspiracy, that's IPC 120B, then the core financial crimes. Cheating, under Section 420, and criminal breach of trust, Section 409. And another important one, 477A, which is about falsifying accounts, absolutely key in complex fraud cases.
Okay, conspiracy, cheating, breach of trust, falsifying accounts.
And they also included bribery charges under the Prevention of Corruption Act, Sections 7 and 13.
So quite a list under Indian law. But the key hurdle is always convincing the other country, Belgium in this case. How did they bridge that gap?
That's where the cornerstone of almost any extradition treaty comes in, the dual criminality clause. This is absolutely vital.
Explain that a bit.
It basically means that the acts Choksi is accused of under Indian law, conspiracy, cheating, bribery, falsification, must also be considered crimes under Belgian law. India had to demonstrate that alignment for each charge.
Right, so it has to be illegal in both places. Makes sense.
Exactly. And by listing those specific IPC and Prevention of Corruption Act sections, they successfully argued that this condition was met.
Now, I saw the sources also mentioned they brought in international conventions, UNTOC and UNCC. Was that just bolstering the argument?
I think it was a smart strategic move. UNTOC is the UN Convention Against Transnational Organized Crime. UNCC is the one against corruption. Invoking these helps frame the alleged crimes not just as an Indian issue, but as part of larger global concerns about organized crime and corruption.
So it adds weight.
It definitely has weight, and might have also reinforced the court's view that he posed a flight risk, that prima facie fear of him fleeing Belgium, which supported denying bail earlier.
It shows how determined India was, anticipating challenges. And speaking of challenges, Choksi's defense wasn't just questioning the evidence, was it? They went for a more fundamental challenge.
Correct. His core defense strategy was all about identity and jurisdiction. He argued he wasn't even an Indian citizen anymore, so India had no right to request his extradition.
How did he argue that?
He showed documentation that he got citizenship in Antigua and Barbuda back in November 2017. And then, crucially, he claimed he formally surrendered his Indian citizenship on December 14th, 2018.
Ah, so the argument is, I'm Antiguan, not Indian. India can't ask for me back. That sounds like a potentially strong legal argument.
Yeah.
How did India push back against that?
Oh. India really focused on the evidence of the alleged fraud itself, the movement of funds, and, importantly, Choksi's pattern of behavior, what they presented as repeated efforts to dodge the legal process ever since these allegations first came up.
Actions speak louder than paperwork, perhaps?
Perhaps that was the angle. And to show they were serious, the CBI didn't just send files. They sent teams to Belgium at least 3 times. And they even hired a private European law firm.
Hiring local European lawyers, that signals they knew they needed specialized help to navigate the Belgian system, right?
Yeah.
Especially on sensitive issues.
Absolutely, particularly on the issue that often becomes the sticking point in European extraditions, human rights assurances.
Right. European courts are famously strict about conditions in the requesting country's prisons. What did India have to promise Belgium?
They had to get incredibly specific. It wasn't just a vague promise of good treatment. They had to guarantee exactly where he would be held if extradited.
Which was?
Barrack number 12 at Arthur Road Jail in Mumbai. And this wasn't just picking a random cell block.
Well.
No. India formally assured the Belgian court that this specific barrack meets the standards set by the European Committee for the Prevention of Torture and Inhuman or Degrading Treatment or Punishment, the CPT.
Wow. They had to certify a specific part of jail to meet European anti-torture standards. That's meticulous.
It shows you the level of detail required. The bar is set very high for non-EU extraditions.
So what did those CPT compliance standards actually entail? What specific things did India promise?
The list they provided was pretty detailed. Things like clean drinking water, making sure the food was adequate, guaranteed access to medical facilities, also access to newspapers, TV.
Okay, basic amenities plus some extras.
And crucially, the choice to be treated by a private doctor, not just the prison doctor. And perhaps the most significant promise, given the profile of the case, a guarantee that he would not be placed in solitary confinement.
No solitary. That's often a major concern for European courts. Just think about the bureaucratic effort involved in getting one barrack CPT compliant and then making that a formal promise to another country's court system.
It really highlights how modern extradition for high-profile individuals involves ensuring prison standards as much as making the legal case for the crime itself.
And clearly the Antwerp court found these assurances credible enough.
Yes. By issuing the extradition order, they signaled that they were satisfied with both the legal basis and these specific human rights guarantees.
So India seems to have won on the evidence front, the legal procedure front, and the human rights assurance front, at least in this first court. What happens now? Does he get put on a plane?
Well, not immediately. While this ruling is a huge step, it validates the arrest, validates the request. It doesn't mean an imminent return. That's unlikely at this stage.
Because there's an appeals process.
Exactly. Choksi has the right to appeal this decision to a higher court within Belgium's judicial system. That's a standard part of the process, and you'd fully expect it to happen in a case like this.
So the wheels are turning, but there are more stages yet.
Correct. The process has successfully started and passed a major hurdle, but it's still ongoing.
When that appeal happens, what do you think the defense's main line of attack will be? Will they relitigate the evidence or hammer on that citizenship point again?
Oh, they'll almost certainly double down on the citizenship and jurisdiction argument in the higher court. The first court found the request valid prima facie, sort of on its face based on the info presented.
Right.
The appeal will likely argue more forcefully that his Antiguan citizenship, acquired before he formally gave up his Indian one, fundamentally undermines India's right to even make the request, regardless of the fraud evidence or the prison assurances. They'll try to elevate that jurisdictional challenge.
So for you listening, the big takeaway here is that this Antwerp court ruling is significant. It confirms that India's case and its request hold water under international law and the relevant treaties. It's a procedural win, a validation of their efforts, even with the appeal pending.
And it really shows, doesn't it, that just changing citizenship or moving countries might not be the easy escape route it once was for alleged economic offenders. But it also shows the immense effort required. That detailed work on Barrack 12 and CPT standards tells you how complex these negotiations really are.
Absolutely. It's a reminder that international law operates on these very specific agreements and human rights considerations. Which leaves us with a final thought for you to ponder as this case moves to appeal. How much weight will the higher Belgian court give to that citizenship argument, especially now that the initial court found the extradition request itself valid? If the citizenship defense does succeed on appeal, what kind of precedent might that set for others seeking to avoid extradition by acquiring new nationalities? Something to watch as this unfolds.